Today, the Thurman Arnold Project, the Law, Ethics, and Animal Program, and the Yale Student Environmental Coalition are happy to present today's online lunch talk featuring Professor Peter Carstensen. Professor Carstensen is a senior fellow at the American Antitrust Institute, former attorney at the Antitrust Division at the Department of Justice, and professor of law emeritus at the University of Wisconsin-Madison School of Law. Before I hand things over, just a reminder to save your questions until the end and use the little raise hand icon or type it in to the chat and I will call on you or read those questions. And so, without ado, here is Professor Carstensen.
Thank you. It's a pleasure to be part of this process. I'm trying to figure out how to get my PowerPoint going here. Oh, there it is. Oh. There, I think I got it. As was said, I'm going to be talking about competition issues facing American farmers. And I'm a city boy. And so the question is always, how do you get into this? And indeed, my father, who was born on a farm and grew up in a small town in Iowa, and where he worked frequently summers on his uncle's farms, and went on to become a quite distinguished historian of American agriculture. I just imagine if he were still alive looking at me and saying, "You, agriculture, what the hell do you know about farming?" And the answer is that I didn't know a lot until in the late 1990s, two of my former students, both of whom worked on agriculture issues, got me to come and talk with them and a group of others about how antitrust law related to issues in agriculture. And that session was one where I came in and said, okay, look, I know something about antitrust. What are you seeing as the issues in agriculture? They'd talk about an issue, explain some of the facts, and I'd say, well, that's an antitrust problem, monopoly. That's an antitrust problem of this or that sort. And it got me going. I've spent a lot of time talking with farmers, with ag economists, with policy folks, as a way of getting myself continuing to have a background in this set of issues. What I like to start in talking about the issues in agriculture with some appreciation that there are broader legal and economic conditions that really shape the context in which we're going to be discussing competition. And the first is just thinking about the technology for producing inputs and for producing processing outputs, and especially the role of scale. Large enterprises tend to produce the inputs. Large enterprises tend to buy the results of farming. So in each direction, many farmers face relatively few suppliers, relatively few buyers. That creates a power imbalance going both ways. That is a significant factor in all of the competitive issues that we are going to be talking about. Another important consideration are what I think of as supply and demand characteristics. First of all, the demand for most agricultural products, especially food products, is really very price inelastic, which means that a processor stands to gain a significant economic advantage if it can reduce output coming to the market by a little bit, because it'll drive the price up significantly. On the other side, one of the things that farmers face is, give you the example of cows. They give milk 24 hours a day, 7 days a week. They don't take time off. I have frequently said if Congress would mandate a 40-hour working week for cows, it would change agriculture and competition context enormously. But once you've got the milk, you've got to sell it. If you can't get your milk to a processor within 24 hours, it goes bad. So farmers thus have a very limited kind of bargaining power that based on the supply conditions that they operate under. And that in turn creates a significant limit on their economic flexibility. The last thing that's worth keeping in mind are some of what I think of as the legal conditions. Most farm workers lack a number of legal protections. Many costs that come with farming, and I'm thinking especially of environmental costs, get externalized to other parts of the community, and the farm does not have to realize some of those costs, and especially the big CAFOs, things like that. That changes their apparent costs, makes them appear to be more efficient market participants than they might otherwise be. The last thing that's become very significant, especially on the input side, is the role of patent and other intellectual property rights, copyright, the Digital Millennium Act. These things allow upstream input suppliers to capture all or almost all of the economic benefits that they confer. Theoretically, that's a reward, but historically, farmers got the benefit of innovations because it would lower their costs, increase the quality of their goods, and the farmers reaped the benefits. Now those benefits are often being appropriated by others. Again, that changes the overall context of farming. So these conditions shape both the potential size of firms and the kinds of conduct that's feasible for the firms. It's another thing I like always to emphasize here is that the goals of market regulation are varied. We can think about, and I always use the 4 factors, efficiency, that is minimizing the costs so that participants in the process are not overcharging. They are getting a reasonable return on their investment, reasonable compensation for their labor, but nothing more. Another goal is what I think of as progress, dynamic change, often called innovation these days. And we want independent actors in the market who have the capacity and the freedom to innovate, to come up with new and different approaches to the market, get new products, new ways of producing goods. Another consideration is fairness, and it goes back both to efficiency and progress. We want to have a fair distribution of the gains from the market in terms, again, of making sure everybody has a reasonable kind of compensation. And that's closely related, again, to the notions of equity, that we want, again, to have equitable treatment of all participants. The problem from the standpoint of competition regulation is that these goals can point in different directions. If you emphasize efficiency, you may be more willing to subject more and more producers to various kinds of vertical and horizontal restraints because it is thought that will increase the efficiency, short-term efficiency of the market. If you prefer to emphasize innovation, you may want to keep greater freedom, restrict some of the ability to impose restraints. Fairness may require us to, again, have a different kind of approach to full-bore competition, because that may leave people out, especially those at the margins, and the same thing from an equity perspective. It complicates life significantly when we get that. So just a very kind of thumbnail sketch of the legal framework within which we deal with these issues. The Sherman and Clayton Acts in combination, first of all, prohibit unlawful monopolization. At one time, that was thought to focus very much on actually eliminating monopolists by breaking them up. Unfortunately, from my perspective, increasingly the approach is only to focus on conduct that is deemed to be unreasonably exclusionary of competition, and that, to me, means that monopoly law has become less effective in dealing with some serious problems in the structure of markets. Mergers are to be condemned under Section 7 when they may, and I emphasize that word may, substantially lessen competition. Now here again, what has happened with merger law, increasingly it's not may substantially lessen, and we don't have to tell you exactly how, because we know the empirical work on this is overwhelming. As markets get more concentrated, prices go up, innovation goes down, marginal choice gets minimized. But how exactly does that happen? The economists have any number of different theories of how that can happen. Unfortunately, both the enforcement agencies and the courts are increasingly saying, well, don't just say it could happen for any one of these reasons. Give me a specific reason and often a timeline. That interferes with making for effective merger enforcement. The third leg of antitrust conventional system is the prohibition of contracts, combinations, and conspiracies and restraint of trade. Now, this has got two prongs to it. One kind of conspiracy is your classic cartel. That is a group of competitors who get together and agree either to raise prices to consumers, their downstream customers, or get together and agree to reduce prices or allocate markets in their upstream suppliers. We'll talk a little bit more about some examples of that in a few minutes. In that area, the problem that has arisen with contemporary antitrust law is an increasingly demanding requirement of proof at the pleading stage, where you simply put in an allegation that there's a conspiracy. Oh no, you've got to put in a truckload of evidence that there is a conspiracy. That, to me, is a serious problem and a constraint on effective law enforcement as we move to more and more concentrated markets where collusion can be done with a wink and a nod. The other prong deals with legitimate transactions that are joint enterprises of one sort or another, a contract to supply, a joint venture to produce. Here the question is whether the agreement includes unreasonable restraints of trade. And there are some criteria that could work. Unfortunately, again, courts have tended of late, if they can imagine a possible justification for what might otherwise appear to be an unreasonable restraint, then it is not unreasonable. And so again, we are seeing a reduction in the effectiveness of antitrust law. There's a theme there from my perspective. I should tell you, it is not concurred in by all who deal with antitrust. So I'm in the pro-enforcement camp very much. We also have the Federal Trade Commission Act, which prohibits unfair competition and unfair acts and practices. And that could be a far more expansive control over harmful competitive conduct. Unfortunately, again, the courts have been very reluctant to expand the FTC's authority beyond the scope of the basic Sherman and Clayton Act kind of commands. Within agriculture, we have three important statutes and then another set that I will divert to briefly. Packers and Stockyards Act, adopted in 1920, draws very strongly on the Federal Trade Commission Act, forbids unfair and discriminatory treatment of producers of cattle and hogs, and then ultimately poultry and turkeys producers were added. Originally, the focus of this statute was to regulate the stockyards where animals were sold. As the stockyards vanished in the 50s and 60s, these provisions became important. Unfortunately, the U.S. Department of Agriculture, which is charged with administering this act and which has rulemaking authority, has largely, not entirely, but largely failed to come up with rules that will regulate the markets. And again, remember, we've got many, many hog, cattle, poultry producers, relatively few buyers, disproportionate market power. if you're going to have a workable contract system, and that's what we're headed towards in most livestock production, you need to have some pretty good rules of contracting so that the dominant party does not engage in unfair conduct, discriminatory conduct, exploitive conduct. Talk a little bit more about the failure of the Package Stock Yards Act in a few minutes. The Agricultural Marketing Agreement Act, a product of the 1930s, authorizes the regulation of output in selected commodities, basically milk and other specialized commodities, and regulate marketing as well. In milk in particular, there are what are called milk marketing orders that create floor prices, require prices to be paid to those farmers who are in the milk market order and under its authority. And I'll talk a little bit about that when I get to the problems in the dairy world. The third one is the Capra-Volstead Act, which exempts farmer cooperatives from antitrust law under some circumstances. And unfortunately, the statute does not define what a farmer might be. And so it, again, it's going to create some interesting puzzles when we get to the specifics. The one place, whoops, didn't mean to do that yet. One place where we see some interesting recognition of this disproportionality and the unusual circumstances of farmers is there are a series of specific both state and federal statutes to ensure payment for commodities, because after all, the farmer delivers his milk or his cattle and expects to be paid. What if he deals with the kind of guy who runs off with the animals or the crop and doesn't make a payment? Well, there are a whole series of statutes that recognize that problem and try to deal with it. And that's an important kind of issue. I want to talk now a little bit about the input issues. This is much more the subject of generic antitrust involvement. I'm going to take two areas, both of which are kind of linked these days. Though in seeds, it's mergers, in tractors, it's really the change in the nature of the market. Seeds are, of course, essential for all of our crops. We have seen a series of mergers, Dow to DuPont, Monsanto and Bayer, Syngenta acquired by China Chemical, that took us from 5 competitors to 3. China Chemical would have been, I think, a significant potential entrant into the market if they'd not been allowed to buy Syngenta. Some of the Monsanto Bayer assets were divested to BASF, which is now a sort of 4th competitor. So if you take a positive view, you'd say, well, we've gone from 5 to 4, negative view, 5 to 3.5. Either way, what's happened is you've increased concentration in the seed production. And here, seed production has come to involve genetic modifications which acquire patent rights because the Supreme Court decided that they did, contrary really to the legal history in the area. And so what that conferred, and then the Supreme Court expanded those rights to confer on the patent holder, Monsanto in this case, that has a patent on 1 in 20,000 genes in the soybean, the right to control the soybean. That is, whenever a farmer plants a soybean with a patented gene, that farmer is, quote, practicing, unquote, the patent, and has infringed that patent if they don't have permission from Monsanto to plant the seed. So this confers on Monsanto an enormous enormous power to limit what's done with that seed. And in particular, farmers used to be able to save their seed and replant it for crops like soybeans. Hybrid corn doesn't work, but for cotton or soybeans, wheat, you have the same genetics. You can save your seed. That puts a limit on the price that can be charged for new seed. Well, once you got the patent, no, I can't plant unless Monsanto gives me permission. The courts have refused to recognize this as an unlawful conduct under antitrust law. Again, I think they ought to have, they didn't. Result, farmers are paying premium prices. The gain they get, and there's a real gain from the use of many of these genetic modifications, is being appropriated by the patent holder. I should say, Monsanto was so successful with Roundup, glyphosate, that now weeds have come to be resistant to it. And so they came up with a substitute, dicamba, which unfortunately gets blown around and kills other people's crops. And so this year, the courts put an end to the ability to sell dicamba as a herbicide. So they're going to have to find yet another alternative to the weeds. The second problem that emerges is if you've got a patent on one gene and you get to control the entire genetics, then a licensee, and there are some moderate-sized seed companies that get licenses to produce seeds, they cannot stack on that seed other genetic characteristics to create what might be a better product. But Monsanto controls, or Dow DuPont controls, or BAS controls all of that. So again, it harms competition in the supply market by limiting opportunities. The information collected from farmers, and the producers get an enormous amount of information. And it's really good. This big data is really very helpful in terms of providing a far more sophisticated ability to analyze which crop, which sub-variety of seed, of fertilizer, of herbicide applied when improves the quality of crop, quantity of crop, reduces harm. But this value is being appropriated once again by the seed producers. And if I'm a farmer, what I would really want, you see, is to have a neutral third party that can look across all the options and tell me, well, what you want to do is use a Dow DuPont seed with a BASF herbicide and somebody's fertilizer. Instead, we get a very limited kind of set of options here. The second and related thing is farm equipment. Here, one company is coming to dominate this business, John Deere. They make very good farm equipment. I don't want to say that they got there inappropriately. What you've got is a change again in demand in the market. As the number of farms declines, as the kind of equipment needed gets to be more and more expensive, it's harder and harder for anyone, for us to have a robust competitive market. Farm machinery uses computer systems to understand their repair stuff. And we know this from automobiles. Now, in automobiles, the state of Massachusetts forced the automobile manufacturers to share that data. Long story, but so I don't want to go into it here. For farm equipment, no state has forced Deere and others to share that data with independent repair services, and even more importantly, with the farmer. I remember years ago, my Uncle John, great Uncle John, saying that when he started farming back in the 19-teens, it had to be 50% veterinarian and 50% farmer. And by the 1950s, when we were talking, he said, you know, you got to be 50% mechanic and 50% farmer. Well, notice that 50% is being taken away because the farmer can't do his own repairs. He's got to call in the farm dealer who's going to charge a substantial amount of money, and it's going to delay for a substantial period of time getting the repair made, and time is money when you're working your fields. The other thing that happens, and again, this is a good thing, bad thing, the data from that tractor with GPS is going to a central data source, and so you get a much better picture because ultimately that can be pooled with all that data that the farm equipment makers get. You get a whole good picture of what's going on the farm. Unfortunately, that data is being denied to the farmers. in ways that would let them pool their insights and get access to more data, to better advice about what to do, when to do it, and whose product to use. So these things, you see, further impair the functioning of the supply market. I turn now to output issues, which has been my bigger interest. It really came out of those meetings I mentioned in the late 1990s, because it caused me to discover the importance of buyer power, sometimes called monopsony and oligopsony, fancy Latin words. It's buyer power. And buyer power, the exploitation of buyer power, harms farmers. It harms workers. If you think about what a worker does, it's to sell their labor. And it harms small suppliers generally. If you're the maker of plastic, say, fishing tackle boxes to Walmart, and Walmart is buying a lot from you, and Walmart says jump, you don't ask, do I have to? You ask, how high do I jump? That's buyer power. It shapes these markets, and it's a very, very serious competitive concern, in my view. Unfortunately, competition law has been very ambiguous about the competitive implications of buyer power. This is because the mantra is consumer welfare. Well, buyers are not, the supplier is not a buyer, is not a consumer, and therefore we don't care. Historically, buyer power concerns were absolutely central to the Sherman Act and the Clayton Acts. If you want to have a workable, efficient, fair, equitable, dynamic market system, you've got to be as concerned with buyer power issues as market issues. So now I want to talk about a couple of examples. Dairy. Dairy's been a big issue for me. I'm from Wisconsin, so of course. We have a cooperative, Dairy Farmers of America, with 10,000 members. Imagine a cooperative with 10,000 members. As you can imagine, members play a very small role in this system. And it is engaged in a variety of exploitive and exclusionary acts with respect to other cooperatives and to farmers, with the result that we have some very serious competitive issues of access to farming for dairy farmers. And there's actually a case that's going to go to trial, I think, this spring in Vermont, that's going to be focusing on how some of those issues, or some of that conduct, has harmed farmers in New England by dairy farmers getting exclusive rights to supply a whole variety of buyers, creating systems that, again, exclude and exploit non-members. This is related, I think, to the failure to reform our milk pricing system. Remember that marketing order system, and the access to the milk order. Milk prices rest on the price of cheddar cheese sold on the New York Mercantile Exchange, if you please, for half an hour a day, 5 times a week. That's a lousy way to set prices. Milk prices fluctuate all over the place that don't really tie into supply and demand, but have to do with very few players coming in and manipulating that market. There's been repeated litigation over that. That said, you reform milk pricing, you still have the problem that one of the things that DFA, Dairy Farmers of America, does is they deny access to the milk order premium that comes when your milk is used for fluid milk. It's complicated. It is very complicated. There's only one other academic who speaks of the full farm milk order system, and we can clear a room when we get into the details. But suffice it here, there's a premium for farmers if they are allowed to be part of the milk order system that's worth having, especially in some regions of the country where that premium for fluid milk is significant. Right now, they have to belong to a cooperative that is permitted to participate. And again, that's a change. The old system was any farmer who produced grade A milk, that means milk suitable for human consumption, could participate, could opt into being a participant. That, if we did that, notice that would change the ability of the Dairy Farmers of America to use some of their exclusionary practices, because now I'd sell my milk to a cheese maker, to a ice cream maker, butter maker, whatever, I could still be part of the ordered system. The last thing that's happening is we're seeing a concentration in milk processing. DFA just bought Dean. Yes, the government did intervene to protect some of the consumer interests by requiring the sale of some of the processing plants where DFA already had processing plants. It already had a very substantial business. But elsewhere, what it did was to increase DFA's role now as the buyer of fluid milk, which is the basis then for the premiums that dairy farmers get. We've seen issues arise both in North Carolina and in Arkansas as a result of this change. So dairy, we're seeing just all kinds of problems. In livestock, poultry, and turkeys, I focus first on the AgriStats litigation. AgriStats set up a system to share detailed information from producers, pork packers, poultry and turkey integrators, so they could see exactly what everybody else was doing. Theoretically, this was, you couldn't tell who was who. They were all given numbers. If you knew anything about the industry, you could figure out exactly who was doing what. You could tell if your competitors were adding more turkeys, more pigs, more chickens. And so what that allowed them to reach some kind of an understanding about the amount they're going to produce. That's in litigation. The judges have concluded that there's sufficient evidence to justify the belief that in turkey, in poultry, there was such an actual understanding about production. The Justice Department just brought a criminal case against some of the managers for having fixed prices for chicken wings, I think it was, with respect to one particular buyer, illustrating limiting output makes sense. Limiting prices is much harder to do because you've got so many different kinds of buyers. We have now seen lawsuits brought by people who pay employees claiming that this was also used to fix and restrain wages. And just today, literally today, I saw that a case was brought on behalf of poultry growers, pointing out that this same system allowed the integrators with whom they contract to grow chickens, I should say. In the chicken world, there's no market. Poultry growers contract to grow the chickens. You think of them as running hotels for chickens. And what the case argues is that these AgriStats details allowed the integrators to restrict the number of the quantity of chickens that were grown, fixed the amount that was paid to them. Now here, again, I would emphasize, if I look at this from a public policy standpoint, what AgriStats was doing was a restraint on competition because they were sharing the kind of information that would never be shared in a workably competitive market. That doesn't establish that there was a specific agreement about wages or prices or production. But as a restraint of trade, it seems to me obvious. But so far, I guess one of the cases has begun to focus in on that. I think that's where the focus should be. Beef packers have a similar kind of coordination claim against them, but it's very different because there are only 4 major competitors. The argument is that they coordinated among themselves to fix the output, restrict the output, and the more they restrict output, the more they restrict how much they buy at various times to drive price down. They increase the spread between what they pay for beef and what they charge consumers. And recently we've seen 2 events, both the pandemic and earlier a plant closing, where the spread got to be enormously great. And it required that everybody coordinate their purchases to drive prices down, while at the same time they jacked up prices to consumers. The government has initiated an investigation. Nothing more is known about that at this time. Here, I would emphasize that the structure in both the beef and the pork market, they are both fairly concentrated. In beef, I think it's 85% of all beef in the United States comes from 4 producers. Pork, it's a little bit lower. It's like 70, 75%. that creates buyer power right there. So even if we deal with some of the coordination issues, the agristats issues, the beef packer coordination issues, you're still going to be left with significant buyer power unless you do more to regulate some of those markets. I'll give you another little example. The government, watching in a bankruptcy proceeding, allowed the major lamb importer into the United States to buy the major lamb packing plant, which it then will close in order to expand its beef packing and, of course, increase its ability to charge the price, increase the price of lamb on one side, and probably harm, again, not probably, certainly harm farmers again. Crops, we've seen increased concentration as a result of merger in soybean, cotton, wheat processing, both at the buying level and the processing level. I do want to point out corn. I know many people are not enthusiastic about ethanol, but the neat thing about ethanol from a competitive market standpoint is that a bunch of farm co-ops and other small operations built ethanol plants all over corn country, creating a whole new market for corn. And it really changed the dynamics of the corn markets. Those are working a little more competitively. So it again shows that we can create a diverse competitive structure for markets. It really helps on the selling side. Eggs, I always like it. The egg processors are, a number of the leading ones are billion-dollar publicly traded firms, but they claimed to be farmers and they colluded to limit the amount of the size of the coops, the cages that they put their chickens in. Oh, this is a good thing, they said, but they didn't expand the size of their their egg-producing facilities, which had the effect of reducing the number of eggs being produced. And then, so they started to justify it. Oh, it was a good thing. They actually convinced a trial court to do that, even though it was a naked cartel, and the size of the cages was only one part of what went on. There are all kinds of other examples. Cranberry Ocean Spray, a so-called cooperative, is engaged allegedly in exclusionary claims that independent cranberry growers set forth that showed how their market was destroyed by Ocean Spray. Peanuts, there's a claim that the growers or that the buyers got together to set prices. In both potatoes and mushrooms, they made an effort to create cartels to exclude consumers. Interestingly, in both cases, they tried to hide behind Capra-Volstead, and they were told, no, you can't do that. Downstream, and this is the further problem, all these markets are linked together. We've got mergers in retail groceries that increase the overall concentration, even if the number of grocery stores in any particular market remains, concentration in the individual retail market remains the same. You increase their buying power as you increase the overall concentration in grocery buying. In grocery processing, the same thing has happened. Kraft buys Heinz. Oh, well, they don't compete with each other directly, but they use the same inputs, so you've increased their buyer power. The Federal Trade Commission is the primary enforcement agency that looks at those issues. And despite my efforts over 20 years, I have not been able to convince them to really look at the buyer side. There is, I'm pleased to say, a commissioner right now who has begun to raise those issues once again with the commission. It makes matters worse when there's pressure from groceries up to processors. They have to deal with the downstream buyer power. They look for where can they balance their books. It's the farmer that gets squeezed once again. So look, here's my conclusion. Farmers face structures and conduct that harm their access to supplies, and they're also subject to exploitive buying practices with respect to what they produce. Agricultural markets need better enforcement of current law and significant reform in the law to take account of contemporary market process. Thank you all.